What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to break down the cell phone expert testimony for the Commonwealth. How effective was it? How bored was the jury? What did they learn? We'll compare it to trial number one. Was it better, worse, or the same? And then we will get to the very argumentative and a bit explosive, a little condescending, some disrespect, and definitely from my old wrestling watching days, no love lost between Hank Brennan and the ARCCA experts, but some very interesting timing and things done by Judge Cannoni at the end of the day to give us an idea of what we think might happen. Make sure you guys hit that like button. Let's get to it. All right, so we are going to start with the Celebrite expert, and it's not the most exciting information in the world. And I always wonder, with this trial, what people think that have watched it before and haven't, right? Because so many of us know what Celebrite is. We know all the background. We know the education experience of this guy. The jurors are listening to it, hopefully for the first time. But overall, the presentation of these witnesses to me has been so much cleaner, quicker, tighter. And that usually bodes well for the jury paying attention, understanding, picking up the main points. And I do think that Hank Brennan went over and over again. He went, okay, so here's basically the highlight. Here's the summary. Here is your opinion. We're going to listen to most of that today. I'm going to fill in some of the gaps. But generally speaking, I thought Ian Whiffen, this expert, was much, much better this trial than he was the first trial. I thought it was much less confusing. I would not even call that other cell phone expert myself. They probably will. But I thought Brennan got him to say everything he needs to say for the Commonwealth's theory of the case and for the facts the Commonwealth wanted to get out of this witness. Was it additional to last time? Does Alessi probably have a lot on cross? Yes. We're going to save most of it. Alessi's main point on cross was being precise is important. Is this health data or health care data? And he said, technically it's health data. So Hank Brennan was basically saying it wrong the entire time. That was the main point on a very short cross before we went into tomorrow. And I said, if I was Hank Brennan, I would want the jury to hear Whiffen's recitation of the facts as I see them and get all my points across to them, because he says stuff like the temperature when it goes up and down, so that it makes sense that John O'Keefe was outside this whole time, that John O'Keefe was not walking up and down stairs, and that the search for Jen McCabe was not at 2:27, but was in fact at 6 o'clock, and it was not deleted. So all those highlights Whiffen got out that we've heard arguments about. Now the jury gets to go home and sit on it for a day. Okay. And I saw a lot of people saying, but now Alessi has a whole day to prep. That's true. The defense, Alessi, they have an entire day to prep. They were already prepared, right? Seeing what I've seen from attorney Alessi, I would bet my bottom dollar that he was prepared today to go hard on cross. So I agree that he's going to have more time. He'll probably be even better with another night to deal with it. But I think he was ready to go today. And I'll just tell you, I've been a lawyer on both sides of this. I would have rather got my punches in before the jury left. I would have rather planted those doubts, poked the holes, shown where the issues were with this expert testimony before they went home, because I think they're going home thinking Whiffen was a pretty good expert, a lot of education, a lot of experience, the Celebrite guy fixing the issues. And for me, the good part of his testimony started when he and the Commonwealth introduced a character named Richard Green to the jury, because we know Richard Green is one of the defense experts. And Richard Green reached out and asked about a timestamp that just didn't make sense. And so Whiffen was there to find out the problem and answer it for him. And to me, regardless of what you think about Whiffen versus Green, you like one, you don't like the other, you think one's right, you think one's wrong, this is the first the jury's getting introduced to it. And he is seen as, so I talk, when I give speeches to young lawyers, or presentations, I should say, even to doctors and to experts, be the authority, right? Do your research, get the schooling you need, get the experience you need, be the authority. And to me, on direct, he was the authority. Now, is Alessi going to break that down? Is the defense going to have experts to go against it? Sure. But from my perspective to this jury, and I see people saying he isn't the Celebrite guy. Okay, fine. I bet if we interviewed the jurors as they walked out of the courtroom today, they would have thought this guy was the authority on Celebrite. And I think that's the point and plan of the Commonwealth, which is why the defense now has work to do. So let's listen to him explain exactly how he knows Mr. Green.
You told us you got a call from a consumer or a forensic examiner, Richard Green, about a timestamp. What type of timestamp? For what type of artifact was this timestamp?
It was related to an internet query.
And so there was an internet query on a phone that had a timestamp, and this gentleman, Mr. Green, had a question about it.
He did. He wanted to know how accurate the timestamp was in relation to when the internet query was made.
Did you look into the question?
So Green wanted to know, meaning it sounds like Green had a question, meaning it doesn't sound like Green is the expert or the authoritative figure here, right? He's like, how is this happening?
The query that was made?
In response to Richard Green, at that time, I wasn't aware that Richard Green had made this request until several months later, but it was an almost identical question that had been asked by the troopers here, and that's the question I was able to look into and to answer.
And can you share with us, what was the issue? What was the question that you were actually looking into?
The question was related to a timestamp of 2:27:40 a.m. And an internet query that appeared to have occurred at that time. There was no other information on the device that suggested that that internet query had occurred at that time. So we wanted to know how relevant is that timestamp to when the query happened. So I was able to take test devices, recreate test data to find out exactly what this timestamp meant, and discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance to when the actual web query had been made.
So there you go. Very early on. It was when the tab was open, not when the inquiry was made. That's what he says to the jury. And people are saying he took a course like Trooper Paul. Listen, there was a difference when this guy talks and when Trooper Paul talks. I know there's more coming from the defense. I don't think this guy was, somebody said, yeah, he did not give 100% confirmation on anything. I agree. And I know what's coming, right? So I kind of take some of this stuff with a grain of salt. And I know that they're going to be able to pick him apart a little bit on cross. But I always try to think, if I'm going home for the day, what is the jury thinking? Every day at trial, whatever witnesses go, I'm thinking as the lawyer, what's the jury taking away from today? And I think it's probably mostly good at this point for Ian Whiffen. And it's always so much harder to respond, to fight back versus in the moment if you get your chance to take your shots as a lawyer at a witness. After Whitten, I believe he dropped his phone in the yard on his way in. The rapid calls by JM trying to find his phone lined up. Remember, his phone was under him. So what Whiffen also talks about his camera being covered up in pocket mode. Was it in his pocket? Was it under him? I think it could be either. It is, that stuff is kind of confusing. So it also depends on what is the jury focusing on. Are they focusing on, oh, his education's not good enough? Because most jurors I've seen and talked to is, even if their education's not good enough, if they believe you on the stand and you're a really good witness, sometimes you can get above that. Some jurors are only education focused. And if you're not educated enough, they just kind of throw out what you say, which again, all depends on the person. Paula said, don't you think that the jury was nodding off during the testimony? I know I was. So you guys tell me, I didn't think it was, and again, this is kind of an unfair thing because I saw the first trial. I didn't think it was nearly as boring as the last trial. And yes, I feel like I do have, I've had a lot of caffeine today or something because I feel ready to go. This was an exciting day to me because there was a lot of lawyering going on and there are some differences. So this was a good question. Where is it? Peter, have you ever had a prosecution witness take the stand and discuss how the defense witness reached out to him? No, I haven't. So that's a good thing. And again, the defense witness, I don't think reached out to him, but to the company, but he kind of made it sound like him, which to me, in front of a jury, probably a big deal. Do you believe that Brennan would rather win this case and cares more about that than if he helps send someone innocent to prison? Here's what I'll say. It's just complete conjecture and guess on my point. I think Brennan thinks Karen Reed did this. And I think that sometimes when people, now I'm talking generally, not necessarily about Brennan, sometimes when people think that, the lines can get blurred. And I hate to see it. And that it can happen to law enforcement. It can happen to prosecutors. It can happen to judges. It can happen to criminal defense lawyers. When the lines get blurred and you think you can cross some lines because you're on the just side, that's when the justice system crumbles and falls apart. And we just can't do that. Lauren Bo Barron. Whiffen discredited Jen McCabe's Google search order. Yeah, there was some of that when he talks about when she Googled It's Raining Men versus what lines up with her story. But again, to me, because we've all seen this before, and let's always remember that, the defense has to point that out. They have to highlight that. They have to come on cross and say, when did you say that Google search was made? And then when Jen McCabe is on the stand, they've got to impeach her with that as well, because I don't think the jury is going to keep up with all that unless they're writing it down and they happen to write that down. Do they know how big of a deal all that is? That's another question I have. All right, a little bit more for this clip.
So after you looked into the issue and came to a determination or opinion, did you reach back out to Mr. Green?
Eventually, yes, I did. After I provided information to the troopers, I wrote a blog that covered this information because there was another examiner in Europe who had a very similar question, and I realized that this is a relatively common point of confusion. And then eventually I reached out to Richard Green, offering to speak to him about this issue and clear up any confusion, but never received a response.
So to summarize, there was an inquiry about a phone that made a Google or a internet search. And the question is, what time was that search made?
Correct.
And relative to that inquiry, there was a timestamp on some of the data that said 2:27 a.m.
Correct.
Sustained.
That was just leading. And Hank Brennan led so much today with this witness. And you have to be careful because with the technical, boring witnesses, don't let him lead because then he's just giving the jury answers and he's putting things into evidence with what he says. You cannot allow that if you're the defense attorney, and they didn't. They objected a ton, and they make sure Brennan did not direct or lead his witnesses because you can't, and he's a defense attorney, so he's more used to it. No doubt about it. He is so used to leading witnesses, so that's going to be hard for him to back off of. Okay. Then he goes into, I'm just going to play a few clips here and there about him explaining how the timestamp is with the tab and not with the Google search, okay? Because again, I thought it was a lot simpler this time. Last time it was so confusing and convoluted. This time, much simpler for the jury to pick up on, which is what you need to do. Make it simple, keep it simple.
And say, for example, I start with one tab, I'm looking for the local football score. Can I reuse that same tab for some other search, or do I have to use a new tab to start a new search?
You could use that tab for as long as you wanted, or create a new tab to do additional searches while maintaining the original tab in its current state.
And so what you're trying to demonstrate to the jury is identifying a time on one of these tabs where a particular search was made.
Objection, Your Honor. Sustained as to form.
Could you explain this demonstration as it relates to tabs on these internet searches? What are we actually trying to learn?
So as I showed, there's a field in this table called timestamp. It's actually called last viewed timestamp. And I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated, and how it's relevant or irrelevant to a case.
So if I have one or many tabs open on my phone, each tab will have its own timestamp?
Correct.
And the URL, that's whatever I look up, what I search on the search engine?
Objection, Your Honor. I'll allow it. Is that what's happening?
That's correct. The URL is the address of the page that's being viewed.
So if I have a tab open and I use it continuously, 3, 4, 5, 10 times, will the timestamp change?
No, it will not.
And that's
So to me, this is kind of wild. From everything I've known before this case, I did not know that. Now, I remember from the first trial, that's what he testified to, but so many cases have we seen them use exactly that. And I've never heard an expert say it's when the tab opens up, but when the search is made. So how is this going to change the criminal justice system? I think it's going to. I'll tell you what, next time I have a trial, I'm going to look at it differently and see which way lines up with my client's story, right? I mean, it's really amazing to me. Is this going to overturn some guilty verdicts? I don't know. Is this going to be an appellate issue? I don't know, but this seems wildly different from what I have been accustomed to Cellbrite providing. Michelle L., I was discussing the Lori Daybell interview with my husband, and he said, what did the lawyer who knows everything have to say about it? Ah, that's you, by the way. I can't tell if that's a cut or not. It feels a little like a cut, but I'll try to take it as a compliment. I definitely don't know everything. There's so much I don't know. Charlotte, Peter, can you zealously defend your client this hard if you don't think they did it? Is it possible that Brennan believes it because he wants to? Yes, I can always zealously defend my client's rights, period. But as a prosecutor, it's just so different. If I know she didn't do it or I didn't think she did it, there's just no way. There's just no way. If I don't think I can prove it beyond a reasonable doubt, I don't think I have enough evidence or I don't trust my own evidence. That's the problem. Okay, we're going to jump ahead a little bit more here to his overall opinion. And we're going to get it a couple different ways because I do think Brennan did a good job of bringing it out multiple ways from a high-level summary so the jury can pick up what he thinks is important.
Pages that were being viewed. So using the combination of all those sources, I could see that at 2:27:29 a.m., Safari was opened from the application library on the device. At 2:27:29 a.m., when Safari opened, there was already numerous tabs open in the background. The browser would show in the foreground whatever browser tab was opened when Safari was previously minimized. In this case, we can see, looking at knowledgec.db, that the web page that was being viewed was related to Hockmock Sports, Friday's schedule scoreboard. At around 2:27:30, that tab would have been closed. Now, we don't actually have a time the tab was closed, but based on other activity, this timestamp can be inferred. Essentially, when this tab was closed, a record is created in the browser state database that shows the timestamp 1:59:44 a.m. That would have been the tab at the time that the tab took focus, and then the ARCCA Sports Friday schedule scoreboard URL. At 2:27:31, there was a browser switch occurred, and the last visited timestamp that's held in memory would have taken the time that this occurred, so 2:27:31. This URL was PayPal. There was no navigational event listed in history, so this wasn't a page that was visited from a bookmark or from typing in a URL. It was whatever was currently shown in that tab when the tab was brought into focus. And we know that this exact URL was last visited at 7:40 a.m. on the 28th of January. This is evidenced in browser state and in knowledge C. Around a second later, that tab gets closed, and that record gets written to the database with a time of 2:27:31, because that's the time that the tab was brought back into focus. It gets written with the URL and the title information related to PayPal. At 2:27:33, another tab is brought into focus from the background, this one related to Eastern Bank. Again, the last visited timestamp would be updated because this tab has now been brought into focus, causing the timestamp to change. We know that this particular website was visited at 8:02 on the 27th of January, and there's no new navigational events at this time. So we know it's just brought into focus and visible on screen according to knowledge C and browser state databases. That tab gets closed and it gets written to the database. This again is going to show, and I just noticed there's a typo on here and the timestamp at the top is showing correctly. But essentially it's closed around this time, and the Eastern Bank URL is written to the browser state database with the 2:27:33 timestamp. At 2:27:35, we see that there's a YouTube video shown on screen related to It's Raining Men. This shows in knowledge C, there's no new navigational event for it, but there's also no timestamp in the browser state database at this point. This is because this page is actually, or this tab is brought back into focus a second time. And when it gets brought into focus the second time, the timestamp that's attributed to it overwrites the timestamp that would have been written at this point. Sounds convoluted, but essentially if you imagine that the in-memory timestamp here would have said 2:27:35, but then there's another tab that's brought into focus related to ARCCA Sports at 2:27:36.
Mr. Whiffen, can I ask you a couple questions?
Yes.
This timestamp 2:27:36, does that indicate the time when this tab was actually opened?
Yes. The time that the tab was brought into focus or opened.
What does it mean brought into focus?
If you imagine you could have 5 or 6 or however many tabs in the background, you select one of those tabs to view, it makes it full screen, that would be considered in focus, and that would cause the timestamp to be updated.
So if someone had an open tab that had a timestamp, and then they put it in the background to look at a different tab, but then went back to an earlier tab and opened it, would it create a new timestamp?
It would update the timestamp.
If somebody had an open tab.
So if you have an open tab, you just have no idea when searches are made is what it sounds like. Jim said, in the first trial, Ian said he reached out to RG, Richard Green, after reading his report and contradicted him. So again, what the great part is we don't have to remember if there's some major inconsistency, the defense will bring it up on impeachment during cross, which they should. The way I remember it is Green reached out to Celebrite to be like, what's going on with this? And then Ian Whiffen reached back out to Green, which Ian Whiffen said on direct, and then they never actually got in contact. Is this new way of timestamps dangerous? I don't know if it's dangerous, but I'll tell you what. There are definitely multiple ways to look at this stuff now. Multiple ways for lawyers to argue this. You just went down a notch in my view. See, I don't know everything. I told you guys it took 2 seconds to get this comment from Lisa H. If you would believe this witness is correct, talk to an Apple development for real story. So here's what I'll tell you, Lisa, and that's the point of doing this. And that's what's so great about what we're doing here. The jury cannot do that. They cannot talk to an Apple development person for real. They have to determine, do they think this witness is credible? And in my opinion, most jurors who walk into a case with no bias for either side, they generally tend to believe experts unless they are destroyed and their credibility is destroyed on cross. That's just the way it is. Now, the defense can absolutely break this down with cross-examination and their own experts. But it's not like the jury's going to be like, oh, this guy has no clue what he's talking about. Maybe there is a juror that does that. I'd be surprised if all 12 did. That's all I'm saying. Nothing is accurate. Bottom line, always room for error. The Google search health data radius around your phone. And I think that's going to be something that's very important to the defense, that none of this is accurate. You're even talking about how within 10 meters, this time, that time, when you open a tab, when you make a search, all of that stuff is not fully accurate, right? They have got to break that down a bit, but they got to be careful because they're going to call an expert that's going to talk about this stuff too, and they want his to be accurate, right? All right, the next We'll play a little bit here, a little bit.
Till 6:23:37 when it's opened from the background using the icon in the app library. At this point, when it loads up, the same page that was open when Safari was minimized is shown. So we still see hockenmocksports.com/schedules/girls-hockey/franklin/2021-2022. There's no navigational event at this point, so we know that it wasn't completely reloaded. It's just showing what was on screen previously, and it's evidenced in the Knowledge C database. At 6:23:49, there's a cache file created. The cache file is related to how long to digest food. Now, these particular cache files show up as suggestions in Safari. So as you're typing in a query or a word or a URL, for example, Safari tries to take that information and make suggestions based on what it thinks you might be searching for. So if, for example, you were to type in how long to die with the word spelled just DI, Safari can mistake that for how long to digest food, and it could present this information. And up until about 12 months ago, this is the information that was provided by Safari. If you were to do this search, if you were to type in how long to DI, you would get the result that's shown at the top of the screen with an image of somebody eating a plate of food. And this is the image that was cached onto Jen McCabe's phone at 6:23:49.
What does cache mean?
Okay, so this was saying it was really 623, not 227 is basically what he's saying here. Linda said, it doesn't work for me about Ian Whiffen. His testimony means so many cases that depend on Cellbrite data could have been wrong. I don't buy it. How many folks are currently in jail based on internet searches? He's not correct. I've been in IT for 20 years. The search happened at 227 period. Also critically think all searches and times were right except for this one. It's ridiculous. Why does Cellbrite even exist if everything is wrong? So you guys brought up a ton of good points that they should make on cross. So what's the point of all this? Why do we keep any of this, right? This doesn't tell us anything. So that's what they have to do on cross. But that's why I'm saying, as a lawyer, it's great that basically all the jury heard was direct today. We've talked about this a ton, and I hope you guys can stick with me on this because a lot of you guys feel like you know the answer in this case. And most of the time as we watch, the evidence and everything is confirming that and is saying, yes, look, or, oh, that's BS. I don't believe that. The jurors might start to do that too. So if they go home believing Ian Whiffen is the end all be all, maybe the cross is not going to be as effective as if it would have happened immediately. That's what we lawyers think sometimes in trial, at least. And that's all I'm telling you is as a strategic thing for a lawyer. Also, people are saying, oh, this is another shady lawyer tactic playing games. No, like I'll just tell you from my perspective, when I put on a witness, I believe what they're saying, and I want the jury to listen to it and think about that before what I would say is the other side twisting words and tricking and bringing things up and nitpicking on cross, right? That argument works both ways. It's not a lawyer trick to have them go home without cross. It's better because they're listening to the testimony you believe to be true before it gets twisted and mangled and, you know, the lawyer does lawyer things on cross. So it works both ways. It's not a sneaky trick. It's an advantage for your client and your evidence for them to be with you on this case and see it the way you see it. As a juror, it would be very infuriating to not have an objection basis since forbid them from including the reason Brennan was just rude and ugly today. Well, when he was talking to ARCCA, it was not in front of the jury. So it's important to point that out as well. Okay, we are going to jump ahead. So what are his opinions to a reasonable degree of medical certainty? Let's listen to those now. As again, every 10 minutes, Brennan does a good job of the high-level summary. What do you want the jury to know?
That's something that was brought on purpose.
Mr. Whiffen, I have a couple of questions about your analysis and your opinions.
Yes.
You showed us a tab that was opened at 227:40, and it had something to do with Hawkmock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 227:40 tab open for Hawkmock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long to die in cold?
I believe it was, yes.
Does your opinion, is it based on your analysis of reports generated by software like Cellbrite?
Objection, Your Honor.
Sustained as to full.
Was your opinion limited to analysis of reports generated by companies like Cellbrite or Axiom?
It wasn't, no. I went into the data, looked at the various different databases, different files that were in use, tested it across many different devices to make sure that my understanding and analysis of it was correct.
In addition to your opinion that the two searches at 6:23 and 6:24 occurred at that time, as opposed to 227:40, did you also, when analyzing the data, come to an opinion whether or not either of those searches actually connected and produced results?
If either of those searches had connected, the information would have been written into the history database. The fact that it wasn't in the history database, it strongly suggests it never completely loaded. And the fact that there is no title information on the browser state tab as well also suggests it never loaded.
And finally, those attempted searches at 623, 624, you mentioned that information at some point was deleted from the phone?
The only records that were deleted were the browser state database records. Yeah, they were deleted from the device.
Do you have an opinion to a reasonable degree of scientific certainty whether or not that information was removed as a natural application of the phone, or was it because somebody took the phone and actually deleted it by hand?
So again, I don't believe it's possible, given the situation and the information that's available, that it would have been possible for the user to delete it. I believe it was more than likely a system event that caused that, but I've not been able to replicate that system event.
I want to take you back to your first opinion, where you opine that
So basically what he's saying there is she didn't manually delete anything on her phone. Okay. That's what Brandon wanted to get out of there, and he summed it up, and she didn't delete anything on her phone, which to me seems wild to think that just that one search. But then later he said thousands of things were deleted. Thousands, I think he said records were deleted on her phone. He didn't say Google searches. He said records or things were deleted on her phone. And I'm like, okay, again, I can't wait to hear Cross, but what's the jury thinking? That's what I'm always thinking. What is the jury thinking? Then we get to John O'Keefe's phone. Before we get there, let's see what other questions we have. Brendan being an outside prosecutor makes the belief Karen Reed's guilt irrelevant. Totally disagree. He's not there to worry about that. He's there to prosecute the case. So special prosecutor or not, every prosecutor's job is to seek justice and find truth. I'm sorry grown adults come onto your channel and insult you when they don't agree with your viewpoint. I truly appreciate how you break down everything down and give your opinion from experience and schooling. Thank you, LNC. What's funny is it's like, I was just listening to somebody say this. It's like some weird phenomenon with the internet today that people just feel like this is what they need to do. Like they hate me or they disagree with me or they think I'm stupid. And they're like, you know what I'm going to do? I'm going to insult him in the chat. It's like, okay, whatever. Bloodhound. According to the CW's own timeline, shouldn't Karen already be gone from the scene at the time of John's last phone unlock, where her Wi-Fi connects to John's house at 12:36? Again, I think that's where Brendan is trying to say, like, the phone was still active after he got hit. This is for the defense to nuke the timeline and for the Commonwealth to prove the timeline to us and the jury. It's 2025. Do we not believe that iPhone Apple hasn't perfected their craft? If Apple data shows the search happened at 2:23, I believe the Apple data not Cellbrite. I mean, that's the hardest thing for the Commonwealth to get over. We have a report that says the search was at 2:27 or 2:23, whatever. We have this report, and you need this guy to do all sorts of mental gymnastics to explain to us why it's not actually what it says. But that's what the defense has to do, because right now they only have the Commonwealth's direct. That's it, right? Netwoman, was accept list. Don't understand how this data can say it was right in front of the flagpole, whereas when I use my GPS to drive and I turn down the street, it says I'm 10 houses before I'm there. Thank you for 2 Reed videos. So Netwoman, we just drove to my in-laws' house, which is like 45, 50 minutes away. And for half the drive, my GPS was saying I was on like a different road. And we're like, what is going on? So yeah, it is pretty wild. And he only kept certain things on his screen and not others. So this is a good transition comment into John O'Keefe's phone. He explains, the times shown based on the tab. And he explains kind of the health and location data. And he gets to the flights of stairs, which is obviously a big part of the O'Keefe cell phone and health data. And he explains it the way the Commonwealth argued it in the first trial. He gives an example. Do you believe it? Because once again, why do they call it flighting or going up flights of stairs? Why don't they just call it elevation changes? If driving and stairs are the same thing, I don't know, but this is the way the Commonwealth's expert answered it.
Somebody who's walking. It doesn't know whether you're in a straight line, walking in zigzag circles, just number of steps.
what if I had my iPhone and I was moving the iPhone, but my feet weren't moving? Would it register?
It could register some, but typically it's relatively good at picking the difference between actually walking or throwing the phone around or shaking it.
The healthcare data, does it store with date and time?
So there's two locations that health data is stored. Primarily a database called health_db_secure, and that aggregates the information into periods of time. So you may have a 10-minute period where it says 100 steps were taken. It could be that the 100 steps were taken in the first 2 minutes, and then virtually nothing was done for 8 minutes there. But there's another database called Cache Encrypted C, which is more granular. It's where the information is written originally prior to it being aggregated and moved into the bigger health database.
You also mentioned that the healthcare data has a term known as steps.
Yeah.
If the movement registers as steps, would that necessarily mean that a person was walking up or down steps?
Sorry, we're talking about steps taken or flights climbed?
I'm sorry, flights climbed.
A flight climbed, according to Apple, is essentially an incline of 3 meters over 16 steps taken. So it wouldn't really matter whether it was walking up a flight of stairs, walking up a steep inclined hill, on an escalator, something like that. If there is movement that appears to be walking and an incline of 3 meters, then that would be considered a flight climb event.
Is there any other ways that the phone could register flights climbed, but the person's not actually walking up or down stairs?
So I did test this a few months ago, driving in my vehicle. I was able to, if I just put a phone on my dock as I'm driving around, nothing was recorded. But I found that if I was actually holding the phone while driving at the same time, then the natural suspension of the vehicle plus the movement of my arm would be considered enough to be steps. And if
Now, again, this could just be being like pessimistic. That seems like a stretch because we know, or at least I think they're going to say John O'Keefe was holding it because Waze was happening. He was on the phone with Jen McCabe getting directions. So if you just put it down, the person that just said this goes against everything we know, like how cell phones work. It's like, oh, no, because you can do it if you just put it, on your car. But if you hold it in your hand, that's the combination, the perfect combo of events that makes it record like you're walking up steps, but you're actually in a car. Feels like a stretch, but I don't know what the jury's going to believe, right?
that motion happened while I was driving up a hill, it would also result in a flight climb event. And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up the same hill multiple times.
In your studies, what elevation change?
So Tanya, I think there is a method to some of Brennan's madness that he wants to highlight a few key points, which is the smarter thing to do than just drone on and on and on with a million questions that are irrelevant. He tries to keep it as tight as he can, which is why he leads the witness sometimes. And he highlights the couple things that he needs to pick out to make for his arguments and to ask other witnesses about.
Would have to be present if you were in a car with a phone and it would register healthcare data as steps. Is there a certain level of elevation that would trigger that?
Yeah, but mom to 8, are you holding it in your hand and doing this? Like Ian Whitman said you have to for it to pick it up. It's like, I don't know.
Again, it's just a 3-meter incline is required.
Did you say 3 meter?
3 meter.
The healthcare data, in addition to being able to give a range of time of movement and defining generally terms, whether it's steps or stairs, is there any other information about healthcare data that is important in your analysis of this case?
Every time he says healthcare data now, I kind of cringe because of what Alessi said on Cross. Jana, that's awesome. And a public defender, that's tough work. That's tough work. So stay in it. It's gonna be tough. You're gonna feel like, it's a thankless job and you work more hours. You're overworked, underpaid. But you can cut your teeth. You can learn a ton. You can do a lot of good there. If what they say is true, why isn't Haz Long the first thing she Googled was at 6 a.m.? I think they're saying it was, but the other stuff was the fillable Google. I can't remember now as I just am trying to think back to that. All right, we're almost done with his testimony here. Goes into the temperature tracking, explains that timeline of John's location data. Phone stopped at 12:24. Waze is closed. It's not perfectly accurate, but he used the 10-meter accuracy or better thing. At 12:32, no more steps or health activity, aka no movement until 6:01. For the flight of stairs, 15 to 50 seconds it takes to figure out that you went up or down, basically. I've got to pull up now the second half of this video. For some reason, they split it into 2. All right, so let's hear what he has to say now about, was he walking upstairs? Again, he highlights that.
Location information, the topography, and the healthcare data. Do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone, walking upstairs, or for some other reason?
Based on the location data, the health data, and the research that I did in the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
He basically says because of where the location data said he was not in front of 34 Fairview or inside 34 Fairview, which I think he has a point there, that was more likely driving up and down. But to me, you could say the opposite. It's more likely he was walking up and down stairs than the location data because it says he went up and down 3 flights of stairs, which that's the problem for the Commonwealth. If you have 2 explanations and you have to say, they both are done by, this science. One's completely wrong and one's completely right. Which is it? Right. And that's, if you're the Commonwealth, you have the burden to prove that. City Gal, can you talk about the Kate Peters affidavit, please? So I heard more stuff's coming out about that. I will talk about it eventually. I don't have time to mix it in with all of this, but I have a lot of thoughts on it. I do have a lot of thoughts on it. I've been trying to pull my dad in maybe to talk about it. There's just so much going on this week. I got to get through today's testimony. Yes, it's any prosecutor's duty to only try the guilty. I'm saying in this case, Brendan was hired to prosecute, not to decide whether to prosecute. I got you. I always am careful to make sure I try to define everything we talk about on this channel appropriately. I said some of this is really boring. I thought the first half was better than the second half. The McCabe stuff to me moved quicker than the John O'Keefe stuff. That's basically it. Let's get to the hearing. Let's get to this ARCCA hearing. Hit that like button if you guys haven't hit it yet, please, and make sure you are subscribed. Okay, make sure you are subscribed. I'm going to get through this, the rest of this cell phone questions that we have, and then we are going to dive into this. I cringed. I was a little bit like, come on, man, don't make us look like that. We're not out here. We don't need to do this. We don't need to argue like this is what I was thinking. That woman. I started to have flashbacks back when he was talking about tests with his own phone and Murdaugh's expert. Oh gosh. Oh yeah, that was something. Cole, I hope the defense cross is concise this trial, thinking of the juror into saying they saw everything as distractors, focus on the Commonwealth's burden and reasonable doubt. Kurt Smith, it's going to be hard for the jury to ignore the backflips the prosecution has to go to make their story stick, and that's the point, and the defense has to highlight that. Maybe a silly question, but couldn't Apple clarify how timestamps work? I don't think they're going to. I don't think they're going to in this situation. BNBOG reminds me of the Murdaugh trial where the test where the guy said he threw the phone and that was his testing. Yeah, it is amazing to me how like unscientific this testing is. Like, were you going like this with your hand? Were you just going like this? Were you just holding it there? Were you holding it up to your ear? Like, what exactly did you have to do? And which one did count as steps and which one didn't? How likely is it the defense contacted Apple? Like, how much is a gotcha? Is this info in the larger scheme of things? I think the people that they're going to call as their experts is really what defense attorneys would do in this scenario, and that's exactly what they did. That's my guess. Okay. Yes, I talked about already how Alessi brought up it's health data, not health care data. But let's get to ARCCA, okay? He has no texts in his possession. Wolf goes first with Brendan asking questions. I thought that was kind of wild. Because he switched from T-Mobile to Verizon, tried to get him, but he couldn't. He provided every email, a dozen or so. He mostly talked to Jackson or Little, not Reed, but not sure about Yannetti. March of 24, after the report was done, is when they spoke to each other. No real trial prep. And then Hank Brennan gets into it, digging in, and we get our first inclination of exactly what this exchange is going to be like.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned,
That's just a little snippet. There's so much more. So much more.
Again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
For Brendan to act like this wasn't abnormal is crazy. Oh, I skipped that part. Hold on. You got to hear this.
Additional material. How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
You done? Like, I like Dr. Wolf's demeanor and almost some of his little smirks that he made, because it's like, what do you think this is, dude? Like, this isn't some kind of measuring contest. Like, you're not going to big shot me. You're not going to big league me here. I'm an expert in what I do. You're an expert in what you do. You do what you do, but you're not going to sit here and make me look like some kind of schmuck because you're trying to make it seem like something nefarious is going on when my opinions have never changed. So even if Jackson and he were talking about this is why I thought this was just wildly unnecessary. Even if he and Jackson talked about every line and every word in his report, they never spoke before he gave his report, and nothing has changed in their analysis. Nothing. It's wild. Now, what are their new opinions going to be? Sure, you can attack them with all it's talking about, but what does that have to do with what happened in the first trial?
Logistics.
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place. Yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were?
And I don't want to go over this over, but Brennan just continues to go over the fees and the schedules and the fees and the fees and the costs when it's like he billed it all under the DOJ case number. All right, we're going to go a little bit forward. It gets, depending on how you look at it, better or worse as we go.
Is that fair to say?
Correct, until I got clarification from them.
At some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
When did you become an advocate for the defense? That question was kind of funny. Tanya, but you love AJ aggressiveness. If you can't see the difference, Tanya, I don't know what to tell you.
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call, letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged
And
it.
that's such a confusing question. He made a comment, then he said something, and then he said, or. That's such a confusing question.
A couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day, after telling them that you had permission, they could use you as witnesses, what did you talk about?
Do you have the records I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them or are you just saying you think what you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got stuck a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back.
I do think there are some things that he said that you can definitely pick apart, like your billing for talking about your family. Brennan brings that up. I thought that was, I think that was probably unnecessary, and you shouldn't bill probably for talking about your family, but sometimes that comes up. I think he was trying to like personalize it for whatever reason. But I will also say, I've talked to experts before, they bill for everything and they love to talk about their qualifications. No hate on them, but I can believe it that they could talk for however long about the education, experience, and qualifications of an expert. And this is probably why Peter is such a dishonest guy. There's no difference. So that makes sense. That makes sense, ACC. Thank you for that. Jen, I went on a 2-hour drive yesterday, phone in hand, multiple elevation changes, so much that my ears were popping. Apple phone, 0 flights of stairs. I'm sure that all these people are doing these testing. Will the jury? Bob Jr., how can Hank speak like that to ARCCA, and how can Bev keep allowing it? Crazy that she let it continue. I feel like there was no need for it. ARCCA kept his cool though. I 100% agree. This in other trials, we've seen the judge be like, Mr. Brennan, there's no jury here. Please just relax and be respectful. You guys are both professionals. If you think he's lying, prove it with your questions and I'll be the decider of that. I thought it was crazy how deep she let him go and how disrespectful she let him be to this witness, especially when compared to what she allows and doesn't allow to Proctor. I just don't think it's necessary. You can be aggressive. You can control a witness. You can even impeach a witness and basically call a witness a liar on the stand with your questions. But from my perspective, I thought Judge Cannoni was going to be like, relax. A couple times she said, save the comments. JB, Peter, he doesn't bill for anything. He's a salaried employee. ARCCA does the billing. So this is another thing where I thought he convoluted it too much. I don't even know if that's a proper use of it. He made it too confusing. He absolutely bills his time. Every expert does. He doesn't get the money. If he bills $500 an hour for 10 hours, $5,000, he doesn't get that $5,000. ARCCA does, and they pay him the salary. He still bills it. He still puts in his costs. Obviously, how's ARCCA going to know how much his dinner costs, right? How's ARCCA going to know how much gas he had to get for driving? He has to submit the bills and the cost to ARCCA. That was too convoluted. I don't know why I didn't just simplify it. But so there were issues like that too. And I get it. If Brendan wants to get annoyed with that stuff, that's fine. But you still don't need to be disrespectful and condescending to a witness, in my opinion. All right. He kept receiving clarification from the DOJ. That's when he started. 40-minute phone call. Okay. Do you typically charge to talk about non-work stuff? It's pretty clear Wolf doesn't like Brennan either, I don't think. Okay. Then he starts calling Mr. Jackson Alan. And I think this is fair game for Hank Brennan to be like, oh, you guys are buddies. But I think he went into it a little bit of a corny way, and Wolf picked up on it. I do think we will be hearing more of this during cross. And then he says, what would you call me? And I was like, oh boy, that's a swing and a miss. He's like, I'd call you Mr. Brennan. Okay.
Again, that wasn't the entirety of the conversation. I think he just briefly asked me about my family.
Oh, now it's brief. Okay.
Objection, Your Honor. No comments.
Now it's brief. And you see the little smirk again. He's like, I see what you're trying to do, dude.
That wasn't the entirety of the conversation. I think he just briefly asked me about my family.
Oh, now it's brief. Okay.
Objection, Your Honor. No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you're friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
So do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Mr. Brennan starts calling him Alan then. Some of that I get. Some of that I get what Hank Brennan is doing. And if that was it, that would be something. But, oh man, he goes too cringe.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all the contact between myself and Mr. Jackson and Ms. Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep this, sir.
I'm not asking for the excuse. I'm asking.
So I don't disagree with him there. We're about to get into a weird thing. But I always love when a lawyer takes the opposite side of the argument that they argue before, right? Do you delete text? Do you have problems with deleted text? Do you have problems with deleted footage, deleted data? Is that a problem for you, Mr. Brennan?
If you did it, did you delete text?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text.
So
he's not my friend, sir.
So you didn't delete text?
I think I just told you that, yes, I did delete the text.
Oh, you didn't tell me, but you just did now. Thank you.
Objection, Your Honor. So next question, no
Okay.
comments, Mr. Brennan.
How many texts?
She's just like, oh, okay, next question, no more comments, like 50 times, and he kept doing them, which, again, there's no jury there. So what is the point? He's like trying to fight with this guy on the stand. That's what it feels like. Most judges I know and practice in front of would have shut that junk down quick. Like, just chill, just chill. And she had to do it for Lally and Jackson last trial. And I thought she did the right thing, shutting that stuff down. Netwoman said, when would it be considered badgering? I mean, he kept asking, are you sure? Are you really sure? Are you sure? Sure. So, I mean, there's no jury, so the rules are a little bit more lax because it's just in front of a judge. Alessi did object a bunch of times, and the judge just let it keep going. Oh, did he? I may have missed that whiff and called Jen McCabe Jen. Interesting. Trish, I think Judge C was personally mad at the defense and ARCCA. Letting Hank go off was personal. I tend to agree. I don't know about personally doesn't like them. She's annoyed at this whole situation, which is why I think she allowed this. Z. McCarthy, can the Commonwealth open the door for the defense saying the feds hired ARCCA, or will Bev not allow regardless? The defense has to step on toes, but Commonwealth can't do anything. I think there's nothing they could do to open the door, frankly. I think they should be able to, but I don't think there's anything that they're going to do. Brendan was horrible to him, and BC never said anything real him in. Why didn't AJ say something? Brendan was trying to nail him. I thought Wolf was awesome. I mean, what's Alan Jackson going to be like? Judge, he's being mean. Like, you can't do that. Unless he was objecting and the judge was allowing it.
Did you delete in communications with the defense?
I don't know the number, sir.
You don't know the number?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep them, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial.
Where were you when you were deleting these texts? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts?
Sir, I just said I delete texts routinely. You're asking me to specifically give you a location at a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like Signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
So here's what I have to say. I have no idea. Never used Signal. I'm learning what it is now through this. Sounds a little sketchy. What I think is the rules, each individual bar's rules is going to have to figure out how to deal with this. Because on one hand, written communication is discoverable between a lawyer and their expert. But on the other hand, you're allowed to have telephone calls. You're allowed to meet in person. And when we try to determine what happens in those telephone calls or meeting in person, there's no records. And we trust expert witnesses to get on the stand and say, this is what we talked about. And so from my perspective, I don't know what the difference then would be between Signal, where they go away, I assume, or there's no record of it, I guess. I don't know if Signal's text or call. I don't know enough about it, okay? I've never used it before. But from my perspective, I don't see the difference between a phone call or a meeting in person, right? There's no record with Signal, right? I mean, is there a record of meeting in person? But you're allowed to do that, and it's just kind of honor system, right? I don't know. I don't get it. I understand why Brennan's highlighting it. I understand why somebody could think it sounds sketchy. I get it. And I get people saying it's not sketchy. I get it. I totally understand that. But I can understand why a lawyer would be able to make it sound sketchy when they have other communications that are text, email, and call, right?
I mean, it's a messaging platform, yes.
Well, encrypted app, isn't it?
What's that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal does it.
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted app when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations do you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple of phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know. How many times did you use Signal with the defense to talk about this case?
Going to allow it.
From what I recall, it was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not?
No, the point is he can only tell you what he recalls and what he remembers. That's the whole point. And Brendan kept asking, like, don't guess. But if you had to say, is it more around this number, more around that number? So he was doing a lot of that, which here's the other reason why. Well, I'll save that.
Not remember.
Actually, I think I'm going to jump to another part here. Yes, perfect timing. You didn't provide the signal calls to the court, did you? No. Again, I thought that was a good point. He probably should have said, we also talked on signal, I guess. Actually, no, that's not true. Alessi on redirect gets up and says, what were you ordered to provide? Records. You don't have records. You can't provide them. They asked for the records, not for you to state that you talked on signal. So Alessi corrected that because Brendan had me thinking, yeah, why didn't you turn that over? We talked about the salary already. Okay, then this whole Cat conversation, this person named Cat, I thought Brendan was it's just unbecoming, I think is the best way I can say it. That's just my opinion. Because it wasn't like aggressive. It was like sarcastic and condescending. That's what it felt like to me.
Did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name?
When you use like words like you believe, that's inappropriate. That's actually wrong. You can say, I believe if you're not positive about something. That's like how it works in our world. That's the frustrating part about all this.
Name of Kat.
I'll allow it.
I think when I arrived here, yes.
Without qualification, the simple question is, you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day, yes.
Mm-hmm. Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Do you have conversations with anybody from the defense about how you get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
Well, I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
I'll allow it.
It's a pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came into trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face?
Yes.
Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson.
All right. We're going to jump ahead a little bit. He talks about how he prepares the outline for himself before he testifies. He highly doubts Mr. Jackson was waiting for it to prepare his direct. But the battle continues here.
There's an email with a document I'd like to attach to this exhibit.
Okay. Exhibit 1. 1.
So you assisted the
Hold on.
defense before your testimony.
Hold on.
Lynn, I'm not gonna put what you put up there, but that made me laugh. That made me laugh really hard, actually. I agree. Like they really needed this $24,000 that he's willing to perjure himself and just lie to Brennan. It's like I get it. I get like the what did Jack say? The feigning indignation or something. It's like I get it, man. But like, you want to know how you know this is all overblown? This is all overblown. We all know it because Judge Cannoni eventually, spoiler alert, cuts off Hank Brennan, cuts off Alessi, says forget it, gives them 5 minutes with Dr. Rechler, and no questioning from Alessi, and is like, everybody get out of here. That's how you know this was unnecessary.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him. Yes.
That's a lot of answers other than the one for my question. The one for my question.
Hold the comments, please.
My question was, you had
For the 5th time.
communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful? Do
Sustain.
you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
Do you think that providing
Like say, Mr. Brennan, be professional. That's what the judge should say at this point. That's what I think.
a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline,
But Joanne, this is not in front of the jury. This is not in front of the jury.
whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Sustain.
Did you ever make any comments or discuss the outline that you provided?
Like that's totally inappropriate. That's not a question. Don't do it. It's like embarrassing at this point. Like this is not just being aggressive and really battling with a witness. This is like doing something. What is a good analogy for this? It's like you're doing something. Maybe, oh, here's a great analogy for this. It's like, this is so perfect. This is just so good, John. Thank you. You just slid a rung lower on my cool ladder, in quotes, kidding, obviously. You addressing some of these crocodile tear comments is awesome. Just makes you feel like a regular dude/juror looking from the outside in. So that's kind of an analogy for this, right? These people can come on and be jerks on the internet and type and whatever. If you ask a real question and you disagree, I love it. Let's disagree. If you say, I think you're dead wrong on this, let's say it. If you say you need to go ask Apple, I will tell you, I don't think I know the jurors can't go do that research on their own and ask Apple, but that's an important difference as we're looking through this case. But when you're just like a jerk to be a jerk and you personal attacks and whatever, it's like you feel entitled to do that because it's the internet and you can type. It feels like Brendan feels like I'm the lawyer. I get to ask you whatever questions. The judge is allowing me to force you to sit your butt right there and to waste everybody's time and money. So I'm going to do it, and I'm going to do it this way. That's what this feels like. It's like because he's doing it this way, and I just don't get it. I don't know why we would want to do something like this as a lawyer.
Defense to help better.
For those of you in the chat, because I know there are some, for those of you in the chat think Hank Brennan's awesome and Karen Reed is guilty, that's fine. And let's work through this and let's talk about it and tell me why. Do you think he's crushing it? Does this make you think this is better? Is this something that you're like, yes, Hank Brennan is really doing a good job? Tanya, do you think when we say Alan Jackson, this aggressive cross was really good, is that what you think about this cross here? Let me know. It's actually direct, but you get the point.
The testimony for the defense.
I did put comments, yes.
When I just showed you that document, you said you just sent it because this is a standard thing. Why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You don't
question.
understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
I'm going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked, if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they're going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from
So I actually thought, wow, that's pretty good. You had a gotcha moment there, but the witness did an even better job responding. And he's like, guess what? When we get in situations like this, here's a hint for you. Every lawyer asks me the same question on the other side. If I don't inspect the vehicle, they're like, oh, can we really believe what this guy says? He didn't inspect the vehicle. And if you do inspect the vehicle, they're like, oh, you didn't need to inspect the vehicle. It doesn't matter. My expert didn't. So lawyers constantly have the same game when they cross-examine expert witnesses. So he's like, it really wouldn't have mattered. And I thought that was a pretty great point from a lawyer's point of view. And yeah, I mean, I don't think Hank Brennan's going to act like this in front of the jury. I think he's too smart to do that. Andrew said mistrial grounds if in front of a jury, probably not to that level. But I don't think the jury would like him more because of it, which is something you always have to worry about.
the defense, if you had called me a witness about not being able to inspect the vehicle, I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct
Like with no hesitation, he's like, no.
examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you.
Don't hide behind the jury. You cannot do that. Like, you should not be allowed to do that as a lawyer. You are not his boss. You are not his daddy. You are not his judge. You cannot do that. What you can do if you want is ask judge, can you please instruct him to answer my question? You can't do that. You just can't do that. You really can't. MT said, Peter, did they not answer his questions 10 different ways? I felt bad for ARCCA because they have been through a lot just to provide objective data. There were some times where I thought he did dance a little bit on the question, and that's fine. Ask him again, pin him in, corner him in, get your question, but do it appropriately. Look, that's our job, right? That's why we make the big bucks. You got to figure out how to do it appropriately and professionally and in the least amount of time that you can. That's nobody cries for a lawyer that our job is too hard, right? Do it right.
Specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. It's only the argumentation.
Did you write that?
Yes,
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis.
I
That
had-
was the point I was trying to make.
I had
Finish.
enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. That's what I was trying to make sure that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your
Okay,
question.
you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes,
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
yes,
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes,
And then do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
well, allow me to explain, if you will.
I'm asking you a question.
Let me explain.
No, I'm asking
So
you, did you
Answer
defer?
answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. But the reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Next question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because for one, I want the jury to have an understanding, again, the jury to have an understanding of
And he reiterated that this was all about the jury, all about the jury. I know this is not in front of the jury. If it was, I think they'd be very, very confused. Would BC allow this if there was a jury there? I think she would tighten it up more. I would have to think that. Caroline, I'm from Massachusetts. Brennan is embarrassing. The way he's behaving is exactly why people don't like lawyers, because of slimy Brennan. Dr. Wolf handled himself perfectly. Kevin D said, yes, he's doing his job. If this was in front of a jury, then I'd be very worried. This isn't, and Brennan is doing great. Okay, good. There's the juxtaposition in the chat. Sandy B, aren't all experts going to be biased to the side that hires them? So yes, and that's what makes this so different. And we're going to get into now, I think we're going to get into, we're not quite done with Brennan's part yet. But that's what makes this case different, is that the DOJ hired him first. All right, I got about 10 minutes max left. He billed under the DOJ, asked if he was compensated by the defense. He said this is a one-of-a-kind situation. Let's listen to that real quick.
Outlines that you were asked on direct examination by Attorney Brennan. You've described this situation.
Oh,
Well, you described
sorry, we are on to Alessi. I must have messed that up. Oh yeah, we are on to Alessi. He only turned over the stuff in his possession. They talked about the order. He billed under the DOJ contract the whole time. Didn't know if the defense was paying, which I thought was a little inconsistent with how he was answering the question on Brennan's side. But it is what it is. And then this was Alessi's the one that got out of him that this is different than any situation he's ever been in.
how it is you viewed the situation. Have you ever been in this situation before where you're under contract with the federal government? There's rules of the road, so to speak, as what you can do, what you can't do. And then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind. And I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure. Yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach?
So this was a one of a kind case, unlike anything he's ever dealt with before. They talk about December of 24. They talked. Jackson thanked him for his time, and he didn't eat, dinner or lunch or anything with them. 2025, the defense tried to figure out if he was going to be able to testify. Eventually, he was, and they started working on the case. He did talk about Jackson preferring to use Signal again, so I wanted to play the part where Alessi kind of talked Signal with the client and with the witness, and the witness explained that it wasn't, I guess, that big of a deal, but we'll see.
25 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me,
Alessi's like, we have all these problems, and we're worried about them kind of infringing on our rights. To me, that doesn't do a lot with the Signal thing. Like, to me, it's more of what's the difference between a phone call, Signal, and a meeting. There's no record of it, right? I mean, I guess a phone call, there is a record that you actually made the phone call, but to me, I don't see a huge difference, and we allow all of that in the law.
it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
And my understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
And he goes into that was not enough for us to prepare our response. We had to get more to prepare our response. And to prepare our response takes time. We need a month. It's not going to be done till May 7th, basically, because they hired this new accident reconstructionist. When Brennan gets back up, he's like, May 7th? Do you know when this trial started? He's like, a week or so ago. He's like, and you should have found out about this in early February. Then you could have been done by mid-March. That's what he tries to argue. And then he kept saying like an intermediary was telling you stuff and doing this stuff with you. And he's like, do you mean the Department of Justice? Let's listen to that back and forth here, because this is actually important, I think.
Correct.
Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you?
Yeah, to me, Sleuthy, the timeline absolutely lines up perfectly with the defense's argument and not with the Commonwealth's argument.
About the trial?
I think that they provided information regarding some of the witnesses that testified with respect to, I think, the reconstructionists, I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
So this was an interesting revelation. The DOJ was giving information to these ARCCA experts during the trial. And it seems like they're violating the rule of sequestration, right? But did the DOJ know for sure that they were going to be called? I think the defense made it kind of clear they were going to call these witnesses, but they were the DOJ witnesses. Is Judge Cannoni or Hank Brennan going to tell the DOJ what they can and can't do? Is this on the defense to tell your witnesses there's a sequestration order? Are experts excluded from the sequestration? You usually have to make that decision, and they're still waiting in this case whether or not they are excluded. They are under the rule unless the judge says they're excluded. It's not a big deal. Experts in like every case, we all agree that they're going to be excluded and it's fine. So I don't know what the big deal would be. But it's not going to stop Hank Brennan from being like, what's going on here?
The one that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No. It was
Yeah.
just verbal
And
communication.
they were giving you updates and summaries of testimony?
They were probably like, oh, this is what the guy said. That's what it sounds like, but still definitely interesting and definitely appropriate questioning by Brennan.
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that. no.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness. Yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did. No.
I'm going to approach, if I may, Your Honor.
I thought Brennan did make a good point at the end where he's like, well, if you guys are going to do more testing, then the other experts would have to do more testing too. And that's something he's going to ask the judge for. And I'm sure the judge is going to allow it, as she should. But at some point, you got to cut it off and be like, okay, we're both ready to respond to each other. Let's go. Let's move forward. There was a point where he's like, I think you're confused. And Brennan's like, I'm not confused. It's like, oh gosh, it was just too much for me today with the arguing back and forth. Then the judge basically cuts it off, and Rentschler takes the stand, and Brennan gets to ask him like 5 questions. There were 6 text messages and 3 phone calls. Brennan's like, there was 23 phone calls. Rentschler's like, I only saw 3, which indicated to me like maybe there's some problem with what's being turned over and who's reading it. And maybe there's some misunderstanding there, but they didn't really dig into it too much. He's never talked to them on Signal, which I also thought was interesting. The DOJ also talked to him throughout the first trial, and they controlled what they did and didn't tell their witnesses. Again, this whole thing to me is like, go ahead, Brennan. Try to tell the DOJ what to do. Try to tell the feds what to do. Good luck. He ate his lunch in a corner, and then he did talk to potentially the defendant and her family, which I thought was, something that's definitely going to be brought out in front of the jury. I don't think the judge cares, but I think it's definitely going to be something on the jury. He said he should be able to have everything done by May 7th. And the judge is like, if I order you to get it done by May 7th, will you? And he said, yes, I will if you order me to. Oh, also, Wolf talked about how he's had personal attacks, harassment, his family, his kids. He had to miss his wedding anniversary because of doing work on this. And I'm interested to see if that comes out at all, depending on how hard Brennan pushes on just how much he's a shill for the defense and biased for the defense. And if he does say that, will Brennan try to use it to say, see, look at how biased he is for the defense because he wants to hurt all these people harassing him, basically. I don't know. We'll see. Going to be incredibly interesting. Let me answer these questions. Hit that like button before you guys go. Please, you must tell us what you think, Bev. Cutting off Hanky, off, ARCCA, in or out. I think ARCCA is definitely in. Isn't his job as a defense expert to help the defense? Yes, but what he's saying is no matter which side I'm on, there's some similar cross questions that everybody asks. Strains credulity. Do you think the judge will allow ARCCA's new testing and testimony in? Yes, I do. I don't know for sure, but I do think she will. Hank was trying to at least stop the new testing and limit the testimony to report only, at most trying to stop them entirely. Yeah, I don't think he's going to stop them entirely. I think she should let it in. Christopher Wells, Brennan was just as unhinged as Mel Kiper was this weekend. Christopher, my worlds colliding. I couldn't feel this comment more. I know exactly what you mean. Chance. So couldn't the defense ask every Commonwealth expert who brought them in and who was paying them? Absolutely. It's fair game. The Commonwealth just doesn't care. Susie, can voir dire be used for future appeals? This is not going to be an appellate issue. The questions he's asking, I don't think. Science sleuths. As an engineer, it's interesting to hear what a lawyer believes is dancing around a question and when it's the question that is being elusive to the truth of the matter. I like it. I like this disagreement. Thank you. Because there's ways we will see things differently for sure. Dorothy, Peter, Peggy was seen laughing multiple times. Sad. Karen, but why was HB acting this way? What was his point? To really battle? I think he was testing him. Can he get him to break? Is he going to look bad in front of a jury? Can he find out new information he can use in front of the jury? And that's why it's like unfair that Hank Brennan gets to question these guys 5 times and the defense doesn't even get to question or have one extra shot at all the Commonwealth experts, which that's kind of the unfair, because when you give a good lawyer the opportunity to hit a witness multiple times, they're going to get better every time. ShamWow, as much as I hate Brennan, if I were in need of legal defense, I kind of wouldn't mind him on my side. And everybody thinks Brennan's going to lose business because of this. I think he's going to gain it. Fire medic. Should BC correct the record since it's clear there was no discovery order? She punished the defense with their opening statement. I don't think she's going to do that. JCS Monroe. Brennan is a joke, but he is allowed to be the judge let HB totally disrespect the witness. The judge has lost control of this courtroom. Bad judges are the weakest part of our judicial system. Bethany, this case makes me so angry. I couldn't watch trial number 1. Doubt I'll be able to watch trial 2. all the way through. The Commonwealth has failed John O'Keefe, and they are so unapologetic about it. And thank you to everybody who gifted memberships, all the new members. This went way too long again, but this was a crazy day. I mean, this was just totally wild. I haven't seen a lot of voir dire hearings like that, but what do you know? Another new thing for this case. I have to run. Make sure you hit the like button. Make sure you subscribe. Come back tomorrow. We will keep breaking down this case together. I appreciate all the comments, good, bad, or indifferent. I love all the questions. I learned so much from you guys here. Hopefully you learned something too. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.